Good evening. I'm attorney Lawrence Berliner. I'm an attorney in the field of special education law. Um, we're joined with our co-host, Jane Faherty, who is the director of the JumpStart program at the Jewish Community Center in Stamford, who's also a special education advocate. And we'll be moderating this evening's webinar. We have our special guest, attorney Eric Broder, who is a family law practitioner. I'll get a little more in detail with his background and credentials. Jane and I are continuing to present our Zoom webinars because after, 5 years, we are still a community of concerned parents and professionals, and we are still learning about how to connect with one another. We have been moderating a series of webinars on a variety of topics in these unprecedented times to address social, emotional, educational impact on our children's educational journey. We are here to empower you as best we can, provide information, resources, and on the topics at hand. We'll be discussing through Attorney Broder various aspects of family law, parenting plan, team of specialists, collaborating on child's best interests, and other topics. Before we begin, I just have a disclaimer. The webinar is being recorded. A copy of the webinar will be provided to each person who is registered. The information in this webinar does not constitute specific legal, educational, or professional advice regarding your child or your child's circumstances and should not be relied upon as such. The webinar does not establish an attorney-client relationship with Attorney Lawrence Berliner, Attorney Eric Broder, or a professional relationship with Jane Faherty, the Stamford JCC. By signing up, you've agreed to receive emails about future webinars and events from the Stamford JCC and the Law Office of Lawrence Berliner, LLC. Please note that Zoom is a third-party provider, not an agent of or associated with the Law Office of Lawrence Berliner, Broder and Orland, the Stamford JCC, or Jane Faherty. The information we provide during the webinar is based upon Connecticut state law, policies, and federal or national law. If you're watching this webinar from another state or country, we've had people from various countries around the world, you should consult your laws and policies that are in effect in your state or your local jurisdiction. Let's see. Jane, what's new? Oh, before we get to what's new, I just want to make an announcement. There is legislation pending at the Connecticut General Assembly affecting the rights of children with special education. It is very important, if you are concerned about how your rights as parents and how your children's special education will be affected, you need to be in touch with your state representatives, your state senators. At the same time, you can read about it almost every night. There are changes going on in Washington simultaneously. You need to be in touch with your local United States representative, and especially Senator Chris Murphy, who sits on the HELP Committee of the United States Senate. The HELP Committee stands for Health, Education, Labor, and Pension. He's on what's called the Committee of Cognizance. So if you are concerned about what's happening in Washington, please contact your United States representative and both U.S. senators, especially Senator Murphy. Jane, how have you been? I haven't seen you about a month or so.
I know, been busy, Lawrence. This is a busy time of year as we come to the end of another academic year, and parents are reflecting upon the progress that children have or haven't made and planning towards ESY programming as well as the next school year. So it's a busy time of year, but just to follow through on what you've said, that if you want to be connected and engaged in understanding and maybe advocating for children with needs on a local and federal level, look locally to the state, but also there's organizations such as the Council of Parents, Advocates and Attorneys who try to have an impact more on a federal level as well. So you can connect and engage in larger organizations as well as CT Seek. but also pay attention to your local school district and become familiar with some of their guidelines, their policies, maybe their budgets, and where they're allocating funds and resources on a local level. Just to be informed so that when decisions are made, you're not entirely surprised by the direction that funds are and resources are being allocated. But beyond that, it's great to be here this evening and to talk about a subject we actually haven't tackled before, Lawrence, which is interesting. In the 5 years, we haven't really broached divorce, which unfortunately we know that families that have children with needs might be navigating more frequently than other family dynamics and scenarios because of the additional stresses and strains placed socially, emotionally, as well as financially upon individuals. So it's great to have you here tonight, Attorney Eric Broder, to share in our conversation.
Thank you for having me, guys. Looking forward.
Attorney Broder is the founding partner of, well, I knew it as Broder and Orland. It's now Broder, Orland, Murray, and DeMattie, with offices in Westport and Greenwich. The firm has a superb reputation in the field of family law. I can go over all of Attorney Broder's accolades and all the awards, but I'm going to skip to bottom line. He's very knowledgeable in the field of family law, and he's here today to discuss many questions that we have received in advance of tonight's webinar. We ask that if you have questions during the webinar that you use the Q&A section or feature at the bottom of the computer and not the chat. The recording of the webinar includes the chat, but it does not include the Q&A. We do have contact information, some resources in the chat for Attorney Broder, his law firm, an article that is on his website, Jane's contact information of mine. I think COPA, C-O-P-A-A, is the national organization. So without further ado, we're going to get into areas of divorce, children with parents with special needs. One of the things that I found striking, and I've seen this statistic before, and it's in Attorney Broder's on his website, is the percentage of parents of children with special needs being divorced, whether it's 87% or 80% or whatever the percentage, it's happening a lot. There are many reasons: anxiety, stress, blame, guilt. It doesn't matter. The bottom line is parents either are getting divorced or having difficulties co-parenting. So we're going to get into some aspects of family law, like a parenting plan, a team of specialists, collaboration, how to resolve disputes, role of a guardian ad litem, if any, and if necessary, as time allows, the role of the court and the court services. I don't practice in family law, but I have participated more recently as a spectator in a case, and I'm wondering if the courts are the best places to resolve disputes. So that's a question, not a statement, but we'll leave it to the expert, not me. So without further ado, I'd like to turn this over to Attorney Broder and Jane. I know we have some questions, and you want to touch upon anything before we get into the questions, please do so.
Well, I'll just follow up with what you said. Yes, the courthouse is probably the worst place to bring any dispute if you can avoid it, especially when you have children with special needs. It's simply put, there are many, many other alternatives to getting these cases resolved, certainly faster, far less expensive, in a far less expensive manner. And, you know, you're essentially letting a stranger in a black robe make a decision, meeting you for maybe over the course of a couple of days for a few hours on a witness stand, only being able to answer certain questions. And they're going to make decisions that affect your entire life. Forget financially, but your children's entire life, or entire minority. So there are so many avenues and ways to try to preempt that. And I will thankfully say that that happens the overwhelming majority of times. you tend to hear more about the ones we were talking earlier about. It's more exciting to hear about a case where there are maybe drug issues, affairs, allegations of abuse, hiding money, than two people that call their lawyers and work out their differences amicably and promptly for the benefit of their kids. That definitely, thankfully, happens far, far more often than the former.
Often I'm dealing, and we have some questions to that effect, where parents disagree over the child's educational, welfare. The child should have a special ed IEP. They shouldn't. The child has a diagnosis of X. No, they don't. We want more services. We want less services. And the PPT meeting, the pupil planning team meeting, there's no independent referee to say, you're right and the other parent is wrong. My experience, Jane, you certainly may have the similar, if not different experience. The school is going to go with the parent whose decision-making is aligned with the school district's position. And that means one parent is going to get what they want and the other one isn't. And from my perspective, that doesn't bode well with fostering collaboration, communication, and it just feeds the mistrust and other negative emotions.
Absolutely. Yeah, Lawrence, when I've been in those situations as the educator, expert witness in a divorce case or as an advocate, I always remind anybody around the table that we're here for the best interest of the child and that we really have to focus on the data, which is something, Lawrence, that we talk an awful lot about during these 5 years. What progress and how can we support that progress through data and documentation? So by bringing things back to facts and actual evidence base, I find that's the best way to start a conversation about what's in the best interest of that child. But what's your suggestion, Eric, from a legal perspective with regard to this?
So when a divorce is going on and there is a difference in, especially a child with special needs who probably has more coaches or people involved, whether it's a therapist, physical or emotional therapist, it's good to have a point person. And I often say, rather than go the guardian ad litem route, which I could talk a little more about, try to get what we call a parenting coordinator involved, where the two parents jointly hire a therapist, someone maybe with a specialty with children with special needs, for example, and sort of have them quarterback the efforts to sort of get to yes. Let that person work with both parents individually. If the child is old enough or even doesn't have to be that old, they can meet that child, talk to that child, talk to the teachers. They can almost take on the role of a guardian ad litem, but in a way where they're involved more intimately, they're far less expensive, and they're far more qualified, and they can stick around when the case is over. So the good thing about a parenting coordinator is you can get divorced, and if an issue comes up a month, a year, 2 years later, you have someone that has sort of a track record. When I'm involved in a contentious case, I try to get out early and get that person into the case. But as someone who has to protect a client, I try to allow that particular individual, if needed, either has to testify or work with a guardian ad litem to provide information. But it is certainly the best way to go. And I often get, well, how do we choose somebody? Because obviously, if I say somebody, the other side's going to say no most of the time because I'm the husband's lawyer maybe or the wife's lawyer. If you really can't figure it out, go to the pediatrician. Say to the pediatrician, who are some really good therapists? You know our child, especially if maybe they see that child more often. Give us some names. You can't go wrong when the pediatrician makes a suggestion. And then that person can work directly with the pediatrician and probably has a relationship. So that's sort of my tiebreaker rule. Judges love to, they love to approve these. You get off the court docket and you don't clog it up. And then they have some hopeful positive vibes. You won't be there a year or two later.
Just in case somebody's not familiar with the term guardian ad litem, could you just briefly explain what a guardian ad litem is?
Certainly. In any disputed custody or parenting dispute, and I don't mean a minor one like should visitation be on Tuesday versus Wednesday for dinner. I mean, any substantial dispute, if the parties can't get to yes, the court has the right to appoint a third party. We call them a guardian ad litem or attorney for the minor child. Attorney for the minor child is mainly older children, high school, maybe late middle school. The role of the guardian is they're sort of the eyes and ears of the court. The judge can't get off the bench and go to your house and go to your spouse's house and talk to the teachers or child care providers. They don't have the time to do it, and they just can't do it. There's a bunch of rules. So the guardian sort of goes out and collects all the data. My view on a guardian is they should be trying to resolve the case. That should be their first goal, to do that. But if you can't, that guardian will get on the witness stand and testify as to what he or she thinks is in the child or children's best interests. And you can cross-examine and treat him as a witness. You pay for that guardian ad litem. A lot of times, I'm going to say too often, guardians are attorneys. So they're more expensive. And when it comes to children with special needs, they're certainly less qualified. I mean, I've seen hundreds of cases, right? Is it every other weekend? Does it start on Friday and end on Monday? Is it a 252, 50-50? I'm well-versed in that from repetition. But when children have unique and special needs, you want to have someone that's more qualified, frankly, than me or any other lawyer to go in there. So when I have a case that's contested and we can't get my first step of a parenting coordinator, I get the guardian ad litem involved, and I usually insist on it being a mental health professional, of which there aren't enough, frankly. And that's my own pet peeve with it, but I do try to get somebody involved who speaks the language of the therapists, who speaks the language of the teachers, and understands better than I certainly would, or many other guardians.
If a student is 18 and guardianship is something that they've pursued, does a parent still need to invite a guardian ad litem to come in and make decisions for that transitional period from 18 to age 22 and even beyond 22?
So two things quickly. One, I meant to say this in the beginning, just so everyone knows, I get this all the time. A guardian is not someone that would, God forbid, both parents passed away, would be the child's parent or guardian. I don't mean it like a legal guardian, as some people think. So in Connecticut, unlike our neighboring state, New York, once a child reaches 18, all bets are off, unless the child has severe special needs. At a minimum, they can't go off to college or hold down a basic vocational job. Then if they can't, the obligation could extend a little further, particularly with child support. I know in Connecticut, I believe now it goes to age 26 at a cap. And I'm talking could be severely physically and emotionally disabled. But otherwise, once a child is 18, it's over. That child can do what he or she wants to do. And I almost want to say it's even at a younger age, because once a child is 16, 15, maybe, a child's going to vote with their feet. You can't strap a 16-year-old into a car seat like you can a 2-year-old, right? So it becomes, the time to deal with these issues is so short. And I say this to everybody. I mean, the worst thing the more damage you do in the divorce process, forget about later on in life. I mean, if you want to be able to, go to a child's wedding and sit in the same banquet room, or walk the child down the aisle, or go to a graduation brunch for high school, for God's sakes, be careful what you say to each other when a child is 8, or sit at a soccer game or a ballet recital. I mean, I have nightmares of coaching my kids' teams and watching a little girl walk off the soccer field down the middle with all her friends, and one parent's on the 20 and one's on the other 20, and she doesn't know where to go. And if you screw up your divorce process, that's going to ring loudly for years to come. So I know it's a long-winded way. Get someone involved who's more qualified and can keep the flames really down.
But if an 18, 19, 20-year-old is in a high school transition program and the parents are divorced, but they disagree on maybe some of the elements of that programming, at what point, who would then make those decisions as to what's in the best interest of the student at that age and stage?
So at that age in Connecticut, the court wouldn't have jurisdiction over that child any longer unless they were in a position where they couldn't survive without a parent being involved. If it was if it were a 16-year-old and they couldn't agree, the judge could make an order. And then you'd have a trial in front of a judge, and that judge would make a decision. I can tell you from a case I'm involved in now where I have a child who's turning 17 this summer. The trial dates we were assigned are going to be in the fall in November. And the judge said to us, this is just a few weeks ago, why are we even, there are other issues in the case besides this child who has who was in a special school and in a special boarding environment for a while. The judge said, what am I going to do? Once the child is 18, I have no jurisdiction, and we have a trial in November, and I have 120 days to write my decision.
Mm-hmm.
So even if the judge says, great, this is my order, and I issue it in February or March, it'll be a few months. The kid turns 18, I think, in July. So, you know, we're trying desperately to settle because it's an exercise in futility to spend all that time and money for a 6-month order.
I don't know about Jane, but I've had issues of residency coming up in some of my cases where the parents live in 2 separate towns, and the divorce decree might say 50-50, but the law of residency for education is where you spend a majority of your time. So it can't be 50-50. Do you have that come up where the child spends the majority of the time? Do you have that kind of conflict coming up?
Yeah, more and more, but it gets brought up because there are many, many more 50-50 parenting plans post-COVID. That's a whole separate topic, but now that people aren't traveling as much or can work from home, a lot of these parenting plans, they're not on a train to the city, 5 days a week at 6:30 and home at 8 o'clock at night. They can be with the children more. Often if the parent, I'm going to pick on town, so pardon if I insult anyone's town, but if it's difference between sometimes the New Canaan schools or the Stamford schools, they may say, I want my children in New Canaan schools. In that case, in the divorce agreement, we'll put in the primary residence shall be with the mother. She lives in New Canaan, or the father, and then lay out the parenting plan so that we have the magic words for the New Canaan school district. Oh, the primary is the mom, so we're okay having the children here. That happens.
That's really important because to register a child in a school district, you need to have the documentation to prove where their residence is. So it's helpful that as parents, they can potentially have an option between 2 school districts to make a decision.
Yeah, and affordability becomes an issue between the public schools. Yep, absolutely. So we do address that.
We often, at least I often am dealing with children who are in private special ed schools, and I have settlement agreements, and one parent is in favor of the private special ed school and the other one is in favor as long as it doesn't cost me anything. And so I get into indirectly, I get into these disputes. I don't purposely. Are there ways around that, parenting plans, court orders, to avoid placing the child, including myself as the child's attorney, in the middle of these polar opposites?
So the court's going to look at the history of the child. If a child's been in a special school for 3 or 4 years, that child, if it's affordable to both parents, will continue in that school most likely. But if it's enrolling a child at a new school, for example, and they can't agree, you're going to be very hard pressed for a judge to not say that the public schools can't take care of that child because they're public employees, right? So a track record of it, yes. And affordability is an issue, absolutely an issue. So once the children are in that school for a period of time, the court does have jurisdiction to order payment of the tuition for that child to continue in that school. But of course, parents can challenge it and say, this is not in my child's best interests. And now it's a matter of where is that child going to go for their next school? And that's where you can get a guardian or a parenting coordinator or somebody else involved. But the court is look, it's slow. It's backed up. So in Stamford, if I file a divorce case today, for example, if we can't resolve it, I bet it's about 1.5 years before we're at trial. In Danbury, it's probably a year. In Bridgeport, maybe it's 14 months. And there's no guarantee you show up to court that day and it doesn't snow and they say there's no court today and sorry, your February trial dates are off. We'll see you in July. Or we ran out of judges, or there were too many emergency motions filed, so you go to the back of the line. Oh, you're the youngest case. Now they'll try to work on cases with children's issues and give them priority, but you just never know. You can, I guess sometimes get dressed up with my boxes and the whole thing and all ready to go. And sorry, we don't have a judge for you. Or sit around till 2 o'clock. Come back tomorrow. And people pay for that. It's stay out.
So one of the questions we were asked before the webinar tonight was, what is the difference between divorcing and separation?
So it's funny. We have a bunch of blogs we've written for years on our website. And after Can I Tape Record My Spouse? This is the #2 blog that's always looked at. So, Can I Record My Spouse? Is always #1, but this is #2 every year. So there's I know it's not, sorry for little comic relief, but it's true. There's almost no difference. So if the husband moves out, that's not legal separation. It's also not abandonment, unless the husband disappears, for example, and stops supporting the family or providing any money. But a separation or legal separation, you go through the same process as a divorce. It gets approved by a judge, the same discovery, financial affidavits, you need custody orders, all that continues. But the difference is once you're legally separated, you're not divorced. Now, I probably do one every 2 or 3 years. The only reason not to do one is maybe very, very religious people in certain religions, very religious. It used to be that this is pre-Obamacare, so I'm dating myself, but you didn't want to lose health insurance coverage. Now everyone get health insurance coverage, so it's not an issue. But after legally separating, a week later, if one spouse wants to convert it to a divorce, they can, or 10 years later. The only sort of litmus test is at the time they're going to do so, the other person wouldn't be a charge on the state. So if the wife or the husband, that doesn't matter, goes to perfect the divorce, that the state of Connecticut's not taking care of that other spouse because they have no money or had a disease, a disability or illness that they couldn't really function. So I can't tell you, people ask all the time. I don't even remember the last time I've done a legal separation.
So there's no financial benefit to the child, whether from state funds or receipt of state funds or access to funding, a divorce versus a separation. The devil is in the detail of the agreement. Is that correct?
Yeah. In fact, I've heard from parents with college-age children, sometimes there's an advantage because there's a lower income household. I don't know enough about FAFSA to get into it. I don't far from an expert, but I've heard that being divorced has given some parents an advantage. But that's hearsay.
And we're not advocating for divorce.
No, not for that reason, especially.
You mentioned in passing, alternatives to the actual judge making a decision. Are there services through the court system, court mediators, private mediators? I've heard something before we logged on about court services. Could you go into that a little bit?
Yes, I'm gonna dive to the deep end here. So mediation, right? Everyone wants to mediate. It makes great sense. I mediate cases at times, but I have a few rules for mediation, and I'll talk about how that impacts special needs children sometimes. Both people have to want to equally get divorced, because if one parent doesn't, it's pretty easy to, oh, I can't make the meeting. Something came up at work. There's no clock. I couldn't get all the documents together. I only got some of them together, right? The financial discovery rules, there are none in mediation. So you don't always know if you're getting something. So if both parents aren't financially literate at a close enough level, you don't know what you're missing. If there are major issues concerning children, again, not about what night to have dinner, mediation is not always the best route. And mediations, and if there's a parent that has a more control over the other parent, or is the more dominating figure, or we hear the word narcissist all the time, but that is not a candidate for outside mediation. You're each better off with your own attorney. It doesn't mean you need to knock it out, drag it out fight. Not even close. Litigation is a really broad word. It's like it's raining. You can have a rainstorm with rain for days, or you can have a drizzle on your car. Most litigation is the drizzle. That's it. You just have two people that are helping work together, hopefully in a more collaborative fashion. If they can't figure it out, the court has the Family Relations Office. So at its basic level, the Family Relations Office are social workers that work for the state that try to help people resolve issues and cases. I can tell you that they do a good job with a lot of parenting plan issues. That's for sure. But probably not with, and then they definitely work with families with children with special needs. They definitely do. But not as much as they do with the regular type of plan. The negative, of course, is they're overworked, understaffed, and they can't really dive in as much as they probably need to give some help. But they are there as a first line of defense. I'd say the more common way that we've resolved cases that are highly disputed, and it's expensive, but it's far, far cheaper than court, is at times we'll hire a former judge or maybe a senior, I'm sometimes hired to do it, or a senior lawyer to act as a mediator with your lawyers present. So the clients go to spend a day with a mediator, and it's a lot of back and forth. We do it fairly often because now you have an independent judge that really doesn't have, a dog in the fight, and also has been on the bench and has been practicing for years and has kind of seen it all. The good news about that person, it's not binding, so you can walk out. But often in my experience, one side needs to have their case heard. And now they have a chance to tell their story to an independent person. And I think that therapeutic route sort of helps to resolve the issues. And people spend money on that day, so they're a little more vested to get it done. So if you can't resolve things, definitely encourage your lawyers, if they don't bring it up, to talk about a former judge or a private mediator. I told you I'd go in the deep end. Sorry. I can spend more time there, but I think that's a good enough overview.
No, I also know in a case where things weren't contentious and the parents were in agreement that a divorce was the right course of action for them and their child, that neither party hired an attorney, and they went to the third floor of the courthouse in Stamford, and they met with some professionals there that provided them with the paperwork to complete,
Yep.
the financial affidavits, the documents that you signed to file divorce, and those individuals took the time to make sure the paperwork was filed correctly and completed appropriately so that the judge would move it forward to completion.
Yep.
So that's unusual, and that is very inexpensive. It's a few $100s, but I do know that has been an option for non-contested, mutually agreeable scenarios as well. What's your thought on that?
It's great, and it happens more often than you think. I will say that, in Fairfield County, Connecticut, where there are more complex financial structures, getting divorced on the court form is not as easy as check the box, and this is what we're going to do. But in that, I've had people come to me and say, look, we sat down, and they give me the piece of paper or an email with what they want to do. And can they accomplish that? And then myself or someone in my office, we type up the agreement, but we also say, hey, look, these are some pitfalls about what happens if you lose your job. What if your income goes down? How do we reevaluate child support? What are some good tiebreakers? We'll give advice, because my view is a good divorce agreement means you never have to come back to court unless something dramatic happens. That would be a major change concerning a child or children, or a substantial change in income, loss of job, that kind of thing. But whether it's selling a house or dividing accounts, it needs to be done right. I always use the example, those people can go to the third floor and say, we're going to list our house for sale, and we're going to share the proceeds 50-50. Well, that sounds great, and that's what should happen. But what if they can't agree on a listing price? Or what if they list it for, making it up, $500,000, and someone offers $499, and someone says, I don't want to take it? We can build in all the tiebreakers. If an offer is within 5%, or if it's been on the market for more than 90 days and no offers within 5%, do we drop the price? That's a very basic example, but people don't think about that. And what people forget is they go to court, they do the court form divorce, and 6 months, 3 months later, they go to list the house, and now he's got a girlfriend, and she's mad about that. Or the 14-year-old doesn't want to go to dad, and mom's holding the child back, and dad's mad about that. Well, guess what happens with the house? Now we're fighting over whether they have to repaint the living room because the realtor said to do it. So I mean, that's a example. Those are real, those happen. So I love the court form divorce if it can happen, but I think working with a mediator to put your terms into action that alleviates the need to go back to court in the future is really good. I'm a big believer in all contact should be voluntary post-divorce. If it's involuntary because of an agreement that's poorly drafted or misses things, that ain't good.
In the case that somebody, we had a question before, in the case that people are co-parenting, but they were never actually legally married, what advice do you have for people that are co-parenting and supporting a child's needs, but they were never married in the first instance?
I mean, there's no difference whether you're married or not when it comes to dealing with custodial issues for children. The court treats it exactly the same way. So there's no connection there. The only issue I've seen in those cases is you may have a very, very well-to-do spouse and someone who may not be. I've seen the real inequity in the balance where you can't afford to live in a certain town where your spouse is going to live in. And, you know, the courts in a divorce don't want to see one parent living on the water in Darien and the other one struggling in a, you know, fourth floor walk-up apartment, you know, in Norwalk, maybe. They can't equalize it, but they want to make it at least a little bit compatible. So when you have it's tough when you have a very inequitable balance. Sometimes I've set it up where the more wealthy spouse will provide housing in a trust so the child can live in a nicer house with that other parent. And then maybe that house gets sold and when the child reaches age 21 or 18, and those funds are utilized for the child's education. So there's ways of evening the score a little bit from a perspective of equalness, I guess. But the laws on parenting are the same, no different.
We had a question. Originally, I read it one way, and I went back and reread the question a different way. When I first read it, any guidance about sharing information about a divorce or separation, and the way I read it at first with the elementary and middle school, and then I didn't realize it was about the child. So I'm just going to go back to is there any information we should be sharing or not sharing with a public school when parents are in the divorced or in the process of divorce or have some nasty litigation? This comes up in my law practice every so often.
Sure, yeah.
Blindsided by the school district's attorney.
So I'll answer it both ways, and I'll answer the question because I read it the same way you did the first time, actually. So I'll do that second. If there's a restraining order or any restrictions or supervised visitation or anything, you have to let the school know. And you should tell the school right away. The last thing you want is a parent that's not permitted to be with a child at a certain time to show up and say, oh, I'm taking my son or daughter home early. That you want to avoid. I'm a believer that unless it's vanilla joint custody, but there is something unique, and people have asked me, give a copy to the school. Let the principal know. Let the teacher know. You want to make sure that they're not there to police did the wrong parent pick up the child, but if something unusual happens or the child gets sick, they should know maybe who the primary parent is maybe for that day or something and get in touch. The schools will often tell you if there's a real problem, we're telling both parents anyway, right? If it's a major issue, and they should. And the schools will encourage both parents to go to the same parent-teacher night. That kills me. You really can't sit in a classroom with a fourth grade teacher at a little desk and listen to the teacher for 20 minutes tell you about your son or daughter. You need to schedule 2. I mean, that's like the definition of dysfunction. When you talked about how do you tell the kids, which is how I read the question the first time I saw it, I always say, if the child has a therapist or one of your children has a therapist, together, jointly, ask the therapist for a little bit of a script. And if not, go to the pediatrician. And if the pediatrician can't help you, let him or her give a therapist.
Yeah, I knew of a situation many years ago where the child thought there was something wrong with him or her, I forget which, and what they had, meaning the divorce, was contagious to other children. So I have seen that. Are there any, I know we had a couple of questions about financial planning, and whoever asked those questions, we're going to get to that with our next webinar. But in the course of divorce and separation agreements, are there any financial considerations, like besides tuition? Let's say we have extra therapies, occupational therapy, or tutoring costs, or
Yep,
transportation, anything that might come up, say, after or outside of school?
absolutely. And we always put in our plans how unreimbursed medical expenses and extracurricular activities will be handled. Sometimes it's disproportionate based on the parent's income. Not usually crazily disproportionate, but maybe it's 60-40 or 55-45. And here's what my rule is, that no one can incur such an expense without the prior written consent, email or text is fine, of the other parent, and consent cannot be unreasonably withheld. So if your child's been going to a therapist every 2 weeks for the last 2 years, you can't suddenly turn the therapist off unless there's a real reason. Otherwise, your consent's being unreasonably withheld. Just if your child plays, I don't know, is on the swim team and swims once or twice a week at a rec level, and now you want to put your kid in, the Michael Phelps 8-day-a-week program, that's a little different. That requires joint consent, and maybe it's not unreasonable to withhold your consent. Payment's always a big, big issue. So this is sort of my involuntary approach. What I like to do is I like to set up a child fund. And let's just say we're going to put $10,000 in it the day of the divorce. And it's a joint bank account that both parents have access to by use of a debit card or credit card or check. You can't get cash out of that account. And if it's a regular normal expense for the therapist and dad's taking the kid to the therapist and pays the copay of $50, $100, whatever's uncovered, so be it. Comes out of that account. And if the account hits $2,000, each parent puts another $5,000 in. So it's always flush. If it's to pay for Little League, great. We pay it out of that account. Whoever parent fills out the form online uses the debit card or credit card for that account. I'm always going to get, well, what happens if someone misuses the account? We go to binding arbitration. Loser pays the winner's fees. The arbitrator is a lawyer. You can pick a lawyer to do it. And I got to tell you, that self-policing account is one of the best things. And it again goes to involuntary. The worst agreements are, I will send all my receipts to the other spouse within 30 days of the incurrence of a expense. And then that spouse is going to say, oh, you think you're getting paid for the math tutor, the $300. I bought soccer cleats for $120. I'm only paying you $180. Well, I didn't consent to those soccer cleats, blah, blah, blah. No, BS. If it's all in one fund, you have transparency. You can look online instantaneously. And if you don't like it, go fight it out with an arbitrator, and loser pays the winner's fees. That's the British rule.
So
Not the American rule. I take that all the time.
what do you do in the instant that the parents fundamentally disagree about a child's diagnosis that a school district or practitioner has presented the child with or the parents with?
So now you're getting to the real heavy lifting and hard part. The court could order a psychological evaluation of that child, which you pay for, and it usually is coupled with a psychological evaluation of the parents. And now a psychologist or psychiatrist is going to do probably a 90, 100-page report, and nobody looks good. There's no one that will pass that report. It's just different levels of bad. And that will be something a judge will consider in making a decision, probably a year after the process starts, and 6 figures in expenditures between the parents to get to that point, between their lawyers and other experts and other counterparts. Those are the worst of the worst cases. Thankfully, they don't happen that often. But as soon as an expert comes out and says, dad has issues, he's this, guess what dad does? He hires an expert to counter that. Or mom has these issues, she hires an expert. And it becomes a colossal, sad case. They're kept confidential, and only the lawyers are supposed to maintain those. But you can imagine what people say and do with those things publicly.
So is it not like an independent educational evaluation where you want to specifically see what the areas of developmental domains the child needs to work upon, or what diagnosis might be attributed to that? Is it not that kind of evaluation?
I guess I spoke a step too beyond that. Yes, that's what I would start with. And hopefully both parents will be on board. But assuming the parents don't agree, Now it's another evaluation, and often it winds up, right? If one parent doesn't agree that their child has certain issues, that parent thinks that other parent has their own psychological issues. And all of a sudden, it becomes about the parents, not about the kid. And that's bad.
Who's paying for all of these evaluations, whether they're court ordered or private? I disagree. I'm
Yeah.
going to get my own neuropsychologist evaluation. No, I'm going to get my psychiatric. No, I'm going to get some other. Who's paying for all of these evaluations?
In Connecticut, those legal fees and expert fees generally come, quote, off the top. So if a family has, I'm making it up, $500,000 in a brokerage account, all that gets the legal fees for both sides and those expert fees and the guardian fees comes off the top. So if at the end, one party spends $250 and one spends $150, there's $100,000 left to divide. Now, there are cases where somebody overdoes it and you might get some reimbursement later, but that's not common. But to me, that's the greatest deterrent, because if you're going to be aggressive, you're now also funding half of your spouse's defense to that aggressive activity. So there are times you have to be. If child safety or needs are at play, no, you've got to do what you got to do. But if you're going to take some pot shots or some low-level shots, you're paying for the other side. So the lawyers make more money. I mean, just tell the client. I mean, it's silly, but you're just paying your lawyers to do stuff that you don't need to spend the money on. And if your client doesn't listen, you know you have the problem client.
We had a question come in about medication issues. One parent agrees with the medication plan and the other parent disagrees. Is that something part of a court order, parenting?
Yeah, that's a rough one where one parent will administer the medication, the other parent won't. And you can get a court order that they are to administer. I mean, obviously, if a child needs regular medication and they're off it 2 to 3 days a week, it can be harmful and detrimental. We had one scenario where the father wouldn't give the medication to the child. And for a period of time, my client, she had to go to school in the morning and give the kid the medication right before he walked into the building. And it got to the point that the judge said, if you don't do it, we're not going to allow you to have any more overnights with your child. And in the beginning, they happened to have had childcare. The childcare provider had to go there and help administer the medication and be there as a witness. I mean, which is mind-blowing.
So if a parent is preparing for divorce, hopefully together they're in agreement that they both want to get divorced, to what extent should the parent collect the evaluations completed on their child, the progress reports from the school districts, the IEPs, and any other therapeutic detail or information? To what extent is that going to be taken into consideration? And is that relevant in mapping out the parenting plan or educational plan for that child going forward?
That's a great question. And the best, if someone came to see me today and they couldn't work things out, they were confident they couldn't work things out, I would tell them not to wait. Immediately get all the information, medical record, whatever you can do on your own, get it all together. Because if your child has an issue that needs to be addressed and there's a real conflict, the longer it takes, the worse it is for that child. The sooner we can act on what to do and the more organized you are, the better. I mean, it also works on the financial cases. When clients come to see me the first day, I go, here's all the stuff I'd ask for if I represented your spouse. Get it. The sooner you get it, the sooner your case is ready to proceed either towards whatever level it is. And the more organized you are, I know what the other side's going to do. I'm on both sides. I have just as many men clients as female clients and just as many business owners as stay-at-home spouses. It's not hard. Here's the roadmap. Follow it and get ahead of it. The more organized you are. So yes, get the doctors, get the therapists together. I think if the therapist and the pediatrician, if we're dealing with a medication issue, or a psychiatrist who's prescribing and the psychologist, make sure they're working together. That'll strengthen your case, because a lot of times there's like no contact between the two, unfortunately. So I'm always a big proponent of the psychiatrist that might see the child every couple months, get on board and give reports, really build up your a stronger argument early.
What about the scenario that within a household there's multiple children and they all have different needs? Some might be neurologically typically developing, others might have significant developmental needs. What should a parent or parents do when they need very different arrangements and very different bespoke custodial arrangements or educational arrangements for different household members?
So let's just forget about a divorcing family. People that are intact when they have a child or children with various different needs, and they can't always agree, because just when you're divorced and you can't agree or going through a divorce, it's magnified, right? Every little thing takes on a whole new meaning. If you're married or comfortably or happily married, some of those little fights and little disagreements, they blow over, right? But they don't in divorce, because everybody's watching and no one can take their guard down. So get a professional, go back to what I started with. Get a parenting coordinator, hire a therapist to work with your family together. They're cheaper, they're more experienced, they know they can speak the language better than any lawyer can. And they'll be there forever. So yes, get a third party right away involved to quarterback it.
So it might be realistic to expect that children under one roof might have different parenting, custodial arrangements and plans based upon the individual needs of a child and what's in the best interest of Jane versus Larry, for example.
So yeah, I mean, what you might be getting at sometimes is, it's rare, but it happens where multiple children have different parenting plans. You try to keep the children as a unit together, right? I mean, that's the goal. If there's 2 or 3 children or 4 children, to keep them together. All of them go to dad's, all of them goes to mom. But sometimes you have, I mean, look, intact household, a 6-year-old girl and a 15-year-old boy have a lot of different interests. It's hard to do that. There are times where we'll build in one-on-one time, because I think that goes missing in divorced families. I mean, I appreciate one-on-one time with a child when I get it. It's hard in a divorced family to do that. So yes, to address those needs, we'll sometimes accommodate more time with one parent or different schedules. But it's not like, little Emily's with mom on Monday, dad on Tuesday, but, Bobby's with dad on Monday and mom on Tuesday. We don't do it that way.
Do you ever go to special education PPT meetings or any, or you stay out of that and leave it to people like me?
That's for you guys. I'm not going. No, not a chance. No, I don't. I've been called by sometimes a school for a question about a parenting plan, or is this the right decision? Or this says this. I've never seen this before, but no, I don't go to those meetings. I get the reports, but I don't go to the meetings.
I've had situations where I've worked with very medically fragile and involved students and children that have specific elements of equipment, for example, and that obviously resides in one parent's home and might make extended access to that child more challenging for the adult that doesn't reside in that property. But the parent isn't comfortable having the other one in their home. What recommendation do you have for those unusual but more complicated medically involved scenarios that require pieces of equipment and you might only get one from the insurance company?
Yeah, I mean, thankfully, that's very unique. I've heard of it in a couple of cases. We did one where we did a little bit of a bird nesting arrangement. Now, the father in that case didn't spend a great deal of time, but when I say bird nesting, we did have a scenario where he would be able to spend time at the house with that child, and the mother would disappear, either go into a separate room or disappear. What I thought you might be getting at, which is a lot harder, is there are children with certain issues, especially children on the spectrum sometimes, where they have such a routine and they need to be in a certain location, in a certain house, and be in a certain bathroom or eat at a certain table. And it's really, really a struggle to create a new routine. That's far more common, and it really can be Herculean to do so. But I have heard of parents changing that routine over a long period of time, but the transitions are really tough. And that's where you got to work with a therapist, because you can't, a 12-year-old, 125-pound autistic child who might have not a lot of physical, these are case things, can be physically abusive unintentionally to a spouse. You've got to work really hard. Those are really tough cases. And no matter what a judge says, the judge can't physically bring the marshals to the house and handcuff the kid and throw him and bring him to mom's house or dad's house. That's a little more common and very tough. But I do put some faith in a lot of parents. They do understand, and people get it. And as hard as it is, they'll put the effort forth to make it, work.
Sometimes the thing that complicates it too is not just the parents, but the extended family members that are involved. Do you have any suggestions or advice on those families that are navigating advice, warranted or not, from extended family members?
Keep them out of it. Yeah, I mean, that is definitely one of the biggest, we always hear, well, my mom can watch the kids. So, sometimes this is a little more simplistic. In any case, we have a right of first refusal. So if a parent can't be with a child, I usually say at least a period of 4 waking hours. I'll explain what that means. They'll give they can't call their mother or father to watch the kids. They have to offer parenting time to the other child. So if you have a 6-year-old who goes to bed at 8 o'clock at night, but you want to go out to dinner at 7 o'clock, you don't have to call your ex-spouse and say, you can watch our child, because 4 waking hours, there'll be a babysitter that puts the kid to bed. But if you're going to be out for a Saturday day, all day, to a wedding somewhere, well, then you'd offer your ex-spouse, the right to care for that child first. I get a lot of it. Well, the grandparents can do it. Isn't that great? Well, it is great, but no, the grandparents can do it on your time, if that's the case. It is very tough sometimes, but they have no rights. The parents have rights. The grandparents have absolutely no. I mean, there's grandparents' rights. It's not for this, but it's very unusual. It's not for this topic. So yes, they have no rights. You can keep them out of it.
You mentioned grandparents. This is happening more and more, where I have the grandparents being the parents of the child, or acting as the parents, because both parents, for whatever reason, are not involved. Are there any special considerations when grandparents are, in effect, the parents?
So, yeah, the law has just, actually, a lawyer in my office argued in front of the Supreme Court, and it sort of took the law down a level. It used to be that you had to have a real parent-child-like relationship. I mean, almost as though the other parent was gone. It has been reduced, and grandparents have a little more rights. They don't necessarily have custodial rights to make decisions, but they do have a little more say in the process. And if they are indeed the more observant, parties, they're going to be utilized as witnesses in the case. Now, in a more regular case, if the spouse of my client is going to have his or her parents testify, I'm going to go, I stipulate, she's the greatest mom ever. Okay, I know what you're going to say. She's the best mom ever, and my guy's a bad guy. That's what I would say, because that's what always happens. So, but if there's real observations with like a special needs child, and they have a role where every Monday and Wednesday they pick them up and spend 3 hours with them and take them to therapy, that's real. That's different than the ice cream cone.
You mentioned parent coordinators. Are there lists or organizations that could be contacted if parents want to get their, retain a parent coordinator or somebody to help them?
I mean, I'm always happy to make recommendations. Any therapist, you don't need a license to be a parenting coordinator. It's sort of a name that's sort of come up. So any therapist can certainly play that role. I've had it where both parents therapists choose the right parenting coordinator, or a third therapist to sort of quarterback it, and that parenting coordinator works with each individual therapist. So it's kind of sad. To be a mediator in Connecticut, you don't need a license. Anyone can be a divorce mediator. The person you bought your cup of coffee from this morning they might do a better job. I don't know, but they can be your divorce mediator. So just choose wisely. Don't do your research. And I will warn a little bit with some of unfortunately, what's happened with guardian ad litems and parenting coordinators is one side is really upset with the result. And they might be totally wrong. They might have done all the wrong things. And then they take to bashing that person online, or they give them reviews or whatever. And they're in a tough spot, a guardian especially. If they go to trial, that guardian picks a lane, or likely picks a lane. And because that guardian has done everything to settle the case. And you can imagine what people say. So don't believe everything you necessarily read about those people. You need to know the source from which it came.
Is it true that the guardian ad litem will typically favor the parent that gives them the least resistance with going along with their suggestions? Or do you advise, we had a question about to what extent should a parent continue to advocate for their child during divorce?
Well, I mean, if there's a point where everyone's telling you it's not going to happen, then don't do it, right? Then it can backfire. So if the guardian and maybe third parties are saying this parenting plan you want is not going to happen, it might backfire on you. It's a good point to stop. Now, this is the unique thing about children in divorce. When you divide assets, you can never go back and change your mind. You get divorced. I mean, you can do it voluntarily, but the court can't order assets to be redistributed. It's a final decision. But if there's been a change in circumstances, you can always modify a parenting plan. That change might be the kids were 3 and 4, and they don't need they don't need as much time. Or my job has changed, and I can tell you, post-COVID, we had a flood of, I'm being a little bit maybe sexist, but sorry, from a sexist side is more dads that used to travel or go to the city were now home. And they said, hey, I want more time with my kids. So you can always make a change post-divorce. And people do. Or I can tell you this, changes are often made and I never hear about it. They get divorced, the kids are 9 and 10, or 8, whatever. And I'll run into somebody 5 years later and they'll tell me, they say that my favorite thing to hear. We never look at the agreement. We just figure it out. The best divorce agreements are the ones that stay in the drawer and never get looked at again when it comes to kids, especially. And it just happens. I mean, look, if you have active kids that play sports or an instrument or karate or dance, whatever they do, and you got 3 kids and you got to be in 3 different towns in Connecticut or God knows where on a Saturday for a hockey game and a gymnastics thing and a music lesson at the same time. I mean, a parent should take the kids. And people just figure it out, they make it happen. So I'm speaking about a lot of the negative side of it and what happens if, but more often than not, people figure it out.
For those individuals that are divorced and then thinking of getting remarried, would you recommend a prenup or a post-nuptial agreement?
If you have the money, get it definitely. No, it really depends. They're far more common now than they, and I'd say they're being litigated now. 20 years ago, they sort of became a little more in vogue. In the last 10 years, I can say we just do many, many more. 30, 40 years ago, they weren't as common. So now they're really being upheld. And if they're litigated, they're being upheld. I think it's important if you are getting married and you have children and you want to leave more to your children than your new spouse. Absolutely. That's a reason to do it. If there's a huge inequity and you want to avoid a divorce battle, absolutely do it. It is so much more common and takes a lot out of it. Also, there's issues about death you can address in the event someone predeceased. You can always take care of somebody and you can always do more than the prenup. But when you have children with special needs, now it's a different story. Because with a child that doesn't, you hopefully have some predictability. Once that child hits their 20s, they'll be at some point, hopefully, self-sufficient. But if the child has real special needs and might not be as self-sufficient as you want to protect that money.
I've also been an expert witness in court for people getting divorced that or revisiting their custodial arrangements after divorce, and they have since remarried. So the child has a step parent involved in the situation. What rights and entitlements does a step parent have in a custodial visitation arrangement or agreement?
I get that a lot. People call me and go, I'm getting remarried. Remember me 5 years ago? Oh yeah, I'm getting remarried. Oh, you're the one that told me you'd never get remarried. Shoot you if you get remarried. That I get it all the time. I'm like, I know, but I changed. And they ask that question. The answer is really none. If you're a step parent, the other parent would have that right of first refusal would come into play. Now, I always try to say that it's really important, sometimes you put in agreements, before you introduce the children to a new significant other, you let the other parent know. And if you can't figure out how to do it, you meet with a therapist to let the child's therapist, so you know how to introduce that person appropriately. You don't want like flavor of the month coming in and out, all the time. Most people hopefully would do that anyway, but you'd be surprised. I don't know the real punishment, by the way. I mean, I've never seen a court go, you shouldn't have done that. Now you have to break up with him. Like I've never, that's not what happens. No one ever goes to court over it, but it gives some guidance and it's a deterrent. And it's the right thing to do.
This has been very helpful. I mean, Jane and I have dealt with numerous situations trying to navigate the rough shoals of paralysis in the parenting decision. And a lot of what you've offered, the guidance, planning, parent plans, other therapists, trying to work it out yourselves without getting a judge who knows nothing about you except what's happening in court or some pleadings or papers that are filed with the court, I think is excellent advice. And so Jane and I want to thank you for taking time out of your busy schedule to share your wisdom, your experience with us and the many people who have joined us this evening. We thank you all for staying on.
Thank you for having me, guys. This is really, I know it's a lot. I have much more to say, but you get bored of me after a little while. But I hope people leave with that idea that it's so much better to try to figure this out. I mean, really, that the courthouse might as well be it's next door to Mohegan Sun sometimes. That's how I feel about it, really. Like, that's how risky it is.
I think the key to any negotiation is communication. And what I'd recommend to anybody going through divorce is to find channels of communication that are going to be effective, whether it is getting a mediator in, whether it is before you meet and discuss your child's needs, you clearly think about what the concerns are, you use data, you use your documentation to have a clear timeline of maybe the supports and services that they've needed and you predict that they might need in the future. But really try and be as objective as possible, and to show objectivity, data and documentation can help support your argument so that it's not always coming from an emotional place, which is very hard when you are a parent with your own experiences of the spouse. It's difficult to put that to one side when thinking about your child's experience with your spouse or your ex-spouse. So communication, clear, concise, and timely communication, which is something Lawrence and I talk about all the time in the world of advocacy, remains true, I think, in navigating something that's very difficult for everybody, namely divorce.
Especially so. We did have 2 questions about ABLE Act accounts, special needs trusts, and whoever submitted those questions, if you're still on tonight's webinar, that's the topic for our next webinar, which will be on June 4th, where we'll have a financial planner and an attorney who is involved with special needs trusts. Jim Fennell is the special needs trust and estates attorney, and we'll have a financial planner, Stephen Aarons. So if whoever asked those questions, great questions, next time. So I want to thank Attorney Broder again for his participation in our webinar. And, a lot of very valuable advice and experience, of which I'm often learning by doing rather than practicing in the field of family law, because these issues do crop up during PPT meetings and due process hearings. And I think the more, as Jane pointed out, the more communication back and forth, compromise, collaboration, the only one who's affected by these battles are the children. And the more we can do to help them get on with the rest of their lives, I think the better. Let's see. So those are my concluding remarks. I have a couple of announcements after Jane has her concluding remarks, and then we want to hear any concluding remarks from Attorney Broder.
I just want to thank you, Eric, for coming on tonight to talk about this topic. And thank you, Lauren. I can't believe we're nearly at the end of another school year. If you need any support, don't hesitate to reach out and contact us, but really use this time to reflect upon your child's progress over the past academic year and start to really think about what supports and accommodations or changes you might need for the ESY and the upcoming year ahead. So I look forward to sharing more with you next month at the next webinar. Thank you.
Yeah, thank you guys for having me. Really, this is anytime I can hopefully educate or lift sort of the hood up of what goes on in our system to scare people away from it. Even though the lawyers benefit, the more people fight. My view is don't fight, figure it out. And it benefits your kids first and foremost. And that's sort of the purview I think myself and I believe everyone in my firm takes. We're not doing something that's going to impact the children negatively, and working together even after divorce can only have a positive result. So I know it might sound a little corny, but it's really true. And like I said a little earlier, seeing clients 5, 6 years later, just in town, tell me things are working out great. That's the most rewarding part of what we do.
If you found this evening's webinar informative, we welcome your continued participation and support. As I mentioned, our next webinar is June 4th. I will be joining Attorney Fennell at Vista Life Innovations tomorrow at noontime. If you have a way of accessing information, if you're looking for, that's on Zoom. If you're looking for information about the Department of Developmental Services and Special Needs Planning, that's at 12 noon. Vista is an organization in Westbrook, Connecticut. In addition to Jane and Attorney Broder, I also have to thank my daughter, who is sitting immediately to my right, off camera, because without her efforts, we can't put these webinars together. She's your contact person. She's doing all the behind the scenes work to put this together. So I want to thank Westbrook, excuse me. My daughter is telling me Vista is in Westbrook. Okay. So I want to thank Attorney Broder again and Jane. We'll see you soon again on June 4th at 7 p.m. when we'll talk about financial planning and special needs trusts. Thank you.